Hey guys, welcome back. Joe Brunsman, insurance broker to the star. So per request, J.B Hunt versus TTEC and Avtex. And this is what I think are some of the lessons that MSPs and SaaS providers can learn from the claims alleged in this particular lawsuit. All right, so a little bit of brief background here. It looks like Avtex was acquired by TTEC. Avtex, they did a bunch of things, or I should say still do, one of which was they're an MSP, but it also looks like they build some custom software. So going through the allegations made in the claim, first kind of note here I think everybody should be aware of is venue of dispute. So you'll see right here it was the court of Arkansas. That's where all this is going to be playing out, as well as various district courts, et cetera, higher level courts pertaining to Arkansas. And so this is but another reason why you can't just borrow somebody's MSA. You have to go to an attorney and get one specifically drafted for you, because there's a bunch of things that kind of go into this on what the particular venue of dispute is going to be. Now, if you're a smaller MSP, or I should say like a normal size MSP, it's probably just going to be the state in which your business resides. If you're a larger MSP or you're working across multiple states, you may have cause to have a venue somewhere where your headquarters is not located, right? So for example, last I looked at Kaseya's agreement, you had to go to Old Jersey, so the Channel Islands between England and France, because obviously there's going to be some type of beneficial legal structure there for that particular entity would be my best guess. All right, so make sure you guys take a look at your MSA, figure out where that venue of dispute is, and speak with your attorney. Next, J.B Hunt Allegations. So I should stress, I'm not taking a side in this. I'm just putting forth the allegations made by J.B Hunt against Avtex and TTEC. All right, so March 2019, Avtex, they got engaged to design and implement an online driver recruiting system for J.B Hunt. June 2019, the MSA and SOW was signed, and it was to implement a Microsoft-designed web-based driver recruiting portal for J.B Hunt. The portal allowed prospective truck drivers to apply online for jobs with it, and you can imagine what goes into that. A whole bunch of PII, names, addresses, social security numbers, that type of thing. So something that you don't want accessed by some type of malicious actor. Now, what was actually in the statement of work here, this goes through some of the allegations further, specifically delegated responsibility for implementing the portal to Avtex, including the requirements of the portal's data security, configuration, and technical support before and after the portal went live. All right, so it looks like they kind of got the whole thing here from J.B. Hunt. It expressly identified that one of the key business issues for Avtex to address was to, quote, mitigate the risk of storing sensitive candidate information, such as PII, in personal email accounts. Now, continuing on, two of the very particular noted statement of work requirements were PII provided during the recruiting and application process is secure. That makes sense. And I'm not sure why this particular element was pulled out, specifically noted within the statement of work, but it said system administrators can grant and restrict access as appropriate. So that could have been one of the underlying issues here. We're not entirely sure. All right, so what allegedly happened? Late 2020, the portal went live. July 2021, a third-party cybersecurity firm reached out to J.B. Hunt and said, hey, a security vulnerability, and this is a quote, might allow public access to the information that was submitted through the portal. And then J.B. Hunt alleges, hey, the security vulnerability resulted from Avtex's failure to simply disable an access feature within the portal framework it configured when it implemented the system for the plaintiff. What this exact alleged security vulnerability is, they never really get into the nuts and bolts. On the technical side, there could be a million reasons behind that. It could be a security issue. It could be something that's just too blatantly technical for the courts to really even need to know about. It could be that there's some type of underlying litigation or future potential litigation, so they're trying to squash that, or it could just come out later in discovery. We're not sure. All right, next, this is some of the strangeness that's involved with this particular case. And I think there's some lessons here that we can all learn from. So J.B. Hunt goes, hey, their elementary mistake was identified and corrected immediately after it was identified, and then the portal was secured before anyone's PII was accessed or compromised by any unknown third party. So all of this revolves around, well, we'll look at the claims here in a second. It'll kind of tie all this together. But then they say, as required by law, the plaintiff notified various attorney general offices across the country of the vulnerability. Now, I am not personally aware of any statute where you have to just talk to or notify attorney generals of a security vulnerability. The laws that I'm familiar with, it has to do with access and acquisition of covered information, in this case PII. So I'm not really sure where they're going with this or why they worded it in that particular way. I have a hunch, which I'll get into, but so far it looks like, hey, there was this problem. This cybersecurity firm reached out to J.B. Hunt. They're like, hey, you have a potential issue here. It might lead to disclosure. J.B. Hunt, I'm assuming with the help of Avtex, corrected the problem. But then J.B. Hunt went ahead and notified attorneys general. And then they say thereafter several lawsuits were filed against J.B. Hunt in various locations. The lawsuits were dismissed on legal grounds, except for one lawsuit which the plaintiff settled for a reasonable amount. So the lawsuits, I'm not sure if there was even legally a breach. The lawsuits were dismissed, and then one was settled for a reasonable amount. So the kind of the question jumping around in my head is, why is anybody being sued here? It seems inconsequential, but I'll leave that for you to decide. This is an example of one of the breach notification letters that I found online. So often you have to submit sample breach notification letters to the various attorneys general, depending upon their particular rules and laws. And in this one, it says, the investigation determined that certain application information could have been accessed by an unauthorized actor. So I think what we can learn from this is, it looks, if I had to put money on it, what I would probably say is the forensics came back and they were like, we're just not sure. And I think probably one of the reasons they weren't sure is it's probably a very large system. You'll see here in a second that hundreds of thousands of people were potentially impacted by this. And the system was probably being accessed from all over the place. J.B. Hunt's a massive organization. So probably trying to pull that thread amongst the hundreds of thousands of threads that were in there could have just been potentially economically unfeasible. Maybe they did the pure numbers there and they were like, you know what, it's going to be cheaper to notify somebody than go through this forensics work, because now with all this forensics we'd have to potentially do, we could end up notifying people late of the event, which could bring rise to bigger lawsuits. Maybe it didn't work out. I'm not really entirely sure. There's just not enough information here. This is an example, George Wilson v. J.B. Hunt Transport, Inc. This is an example of one of the class action lawsuits that got filed. This was in the Western District of Arkansas. And then this was from one of the class action websites. And it says, hackers could have accessed the personal information of more than 231,000 people. News of the data breach hit the internet on August 23rd, but the company did not alert the thousands affected by it until October 18th, according to this website and according to, looks like Mr. George Wilson. So because of the delayed response, he and others are at, quote, significant risk of identity theft, various forms of personal, social, financial harm, that kind of stuff. So you got a lot of moving parts here. A lot of question marks, but where does the money actually come into all this? And this is something that all of you guys probably have in your MSAs, SOWs, etc. And it's this right here. Paragraph 11 of the MSA requires Avtex to, quote, defend, indemnify, and hold harmless the plaintiff from and against all claims arising out of or resulting from provisions of the services that they effectively rendered. Now, why would anybody want to do that? Well, it's kind of like at least from my perspective, it's kind of the rookie way to do it, because a previous video I talked about additional named insured, primary non-contributory, waivers of subrogation. This is just a straightforward defend, indemnify, and hold harmless agreement. So if you guys remember this video, I'll link to it down below, actually. This is where I went through some of those common contract terms that you're going to see. And this was the hold harmless and indemnification agreement. It effectively is, it's just a promise between two people that if one person has to pay out for something, the other person will take care of those payments for him. Now, in the context of MSP services, you don't necessarily want to do that for all things. I'll just leave that up. Talk to your attorney about that, but I'll leave it at that. All right. It has to be narrowly construed because you don't want to go paying for everything. Now, in the context of SaaS providers, it kind of makes sense, right? Because some companies paying you for this software, they're paying you to keep it up to date. They don't really know anything about the software. Then maybe they don't have the code. It could be proprietary information. And so they're saying like, hey, if we get hit or if we have to pay out a whole bunch of money because we were using your software that we don't have control over, we want your insurance policy to pay for that. There could have been a bunch more negotiations around, having J.B. Hunt as an additional insured under Avtex policy, primary non-contributory, so that way that Avtex policy would have paid out first and it could have avoided all this. There's a lot of underlying information here that just is not currently in the court records. Now, the counts of the claim, you're going to see breach of contract and negligence, and that's something that anybody watching this, if you're going to get hit with a claim, it's probably going to revolve around those. Those are very common causes of action. Now, breach of contract here, one, for failing to secure the PII in a secure method, which cannot be accessed. Now, in all fairness, it looks like earlier they said mitigate that threat as opposed to entirely prevent that threat, but I'll let that one go. Two, Avtex refusing to indemnify J.B. Hunt to reimburse them for the cost of the lawsuits made against them. So this goes back to those class action lawsuits made against them. How much did it cost? We have no idea, but it's the hold harmless indemnification agreement. You should be aware that generally that's a business dispute, which is not insurable. All right, that's just a dispute between two businesses. Hold harmless indemnification agreements, not necessarily insurable. Actually, very rarely are they insurable. So make sure you understand that in that particular portion of your contract. Speak with your attorney about that. That's also why I think they're putting in these other causes of action, because I think they're trying to pull money out of Aztec or Avtex/TTEC, understanding that that part of the claim may not be insurable, so they have to put these other counts on there to try and recoup that money. Count number 2, negligence. All right, failing in their duty of care consistent with, quote, the level of skill and competence possessed by like businesses operating in the same industry or field as Avtex. What does that mean? It probably means that you're going to have a war. So I'm sure that J.B. Hunt is going to bring in their expert witness who's going to be like, oh, Avtex should have done X, Y, and Z. We always do X, Y, and Z. It was such a basic mistake. Nobody would ever make that mistake. And then I'm sure the defense for TTEC and Avtex is going to come in and they're going to say, they'll have their particular expert witness say, oh, that mistake, it's a super rare mistake. It probably wasn't within the scope of what they were doing. Nobody could have known about that. So there's probably going to be a war of the expert witnesses going back and forth to figure out who actually is responsible for this and was Avtex negligent in not correcting whatever this particular error was. And then 2, implementing the portal without enabling a simple security feature, specifically designed and intended to block unauthorized access to applicants' PII. What is that simple security feature? Once again, they just don't say inside the claim, so we're kind of left here scratching our heads. Maybe it is a simple security feature. Maybe it's not a simple security feature. I don't know. You have to keep in mind that these complaints, right? We're not looking at the response from Avtex. What we're looking at here are the allegations made by J.B. Hunt. So obviously J.B. Hunt, or really anybody, when they file a lawsuit, it's, woe to me, how could they do this? They should have known better. We're going to have to wait for Avtex to reply to see exactly what their position is here. So is there a limitation of liability clause? I talk about those all the times. What exactly did the contract say? We don't know, it's not included, and specifically you'll see here, pursuant to Rule 10D, good cause exists for J.B. Hunt to refrain from attaching the written contract at issue in this case. They're like, hey, it's a big contract, it's confidential, and the defendants already have it, so we may never actually know what specifically was in that contract. So what does J.B. Hunt want? Well, something in excess of $75,000. I only know that because they brought up the topic of diversity in the legal sense within the claim. So it's something over $75,000. We don't know how much the lawsuits cost to defend, the ones that were, I believe the term was readily dismissed. And whatever the one was that settled for a reasonable amount, I have no idea what that was. I couldn't find it. So for right now, all we know is they want more than 75 grand. Could be hundreds of thousands of dollars, could be millions of dollars, could be tens of millions of dollars. We really have no idea at this point. So who is potentially paying for all this? Who's paying for the cost of defense? Who's going to potentially pay for damages awarded to the plaintiff? We're not sure, but this is a quick cautionary note. I'll link to this one up above. If you're buying or selling a business, there's something called a tail policy, also known as an extended reporting period. Please do not inherit somebody else's potential liability. So however that arrangement was between TTEC and Avtex, I'm sure TTEC isn't particularly happy with this because it's some potential negative publicity, even if they turn out to win the case, but also now they have to deal with some potential baggage coming from Avtex. All right, so if you're acquiring businesses, please make sure you understand somebody is going to be paying for this. All right. And there was a whole bunch of this complaint that I left out where in the very beginning, the plaintiffs effectively weave together, yes, Avtex is now a subsidiary of this other entity, but because of these particular reasons, accounting reasons, etc., we think that both of these entities should be brought into the claim. So because of that, you have to understand there's really no such thing as like, oh, I'll just like sell my business for $1, or we're only buying clients, we're not buying liabilities. Talk to your attorney about that stuff because it's not as simple as people just assume it to be playing lawyer with Google on the internet. All right, so moving forward, what can we learn from this stuff? One, have competent legal counsel review your contracts at least annually. Now, why do I say at least annually? These things are changing so rapidly. So I'm sure this MSP lawsuit, along with the myriad of others, will have some direct material impact on the language that is preferred within your MSA, within your SOW, etc. So don't get left in the dust, using some year-old, 2-year-old, 3-year-old, etc. contract that doesn't provide you the best protection. I understand it's but yet another expense for you, but you have to take it seriously. All right, next, make sure you understand those contract terms. Okay, so if you don't understand the contract terms, if you don't understand hold harmless, indemnification, additional insured, primary non-contributory, waivers of subrogation, force majeure, all that kind of stuff, please talk to your attorney. I have a whole video that tries to break that down, but at the end of the day, just talk to your attorney. That's what they're there for. All right, so please don't sign things you don't understand. Next, not everything is insurable. So keep that in mind with your business savings account if you have a hold harmless indemnification agreement, and I'm sure you do within your MSA. Next, make sure you review your insurance coverages. All right, so 'tis the season, as they say. So make sure you're actually understanding, hey, what type of insurance do I have? Is my tech E&O policy, which is going to be pertinent in this type of case, is it appropriate? Does it cover everything that I'm actually doing? What are the holes in my coverage? What are the exclusions in my coverage? If you guys go to my YouTube channel, well, I guess you're already there if you're watching this, but go check out my other videos. You'll see all types of information I put out for free, where as an insurance broker, I want to make sure you guys are getting the best possible information because you're paying for it, so you might as well understand what the rules of the game are. So once you know the rules of the game, then you can decide, hey, I'm going to bend the rules, I'm going to break the rules. I know the danger of doing that, or I'm going to play entirely within the lanes, but at least now you have an educated basis to make those decisions as opposed to firing from the hip and potentially facing an uncovered claim. All right, and don't buy the liability of others. So tail policies, check it out. All right, guys, if you like this, you found it useful, you learned something today, like, share, comment, subscribe, all the YouTube guys stuff. Right above me is another video that the algorithm will recommend. And if you click over there on my beautiful face, you can subscribe to my channel. All right, guys, with that, stay safe.